Hello, y hola, y bienvenidos, y gracias por venir, y thank you for coming. So, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C. We're a law firm in Oakland, California. We fight for the rights of immigrants who are facing deportation. Really happy and excited to put on our next seminar of the month. And this month we're going to be talking about what are your options if you're actually in immigration court. Así que estoy súper contento de estar con ustedes hoy con otro seminario del mes, y el tema de este mes es qué opciones tenemos si estamos en frente de Corte de Inmigración y sí, qué podemos hacer si estamos en Corte, ¿ok? Así que mil gracias por estar conmigo hoy. All right, so welcome, and so what I want to talk about today is, first I want to do a little bit of an introduction to me and my office, and then we'll get to the main theme, which is what options do I have if I'm in immigration court. So primero quiero hacer la introducción, y segundo quiero explicar el tema, que es qué opciones tenemos si estamos en Corte de Inmigración. Ok, así que la introducción, quiero que cada persona me conoce a mí, porque pues tenemos más y más clientes y no les conozco personalmente. So I want each of my clients to get to know me a little bit better, because we've got more and more clients all the time, and often I don't get to really have a personal connection with folks. And so to do that, so first, this is Otis the Pro. I'm an immigration lawyer. You gotta know me as that. I'm also a family man. My wife Wendy, we have 2 kids. We live here in the Bay Area. Also Otis the Biker. In 2005, I rode my bicycle across the United States. And also Otis the Traveler. I've traveled in 25 different countries. I've lived in 5 different countries. I really believe in, being able to go and meet people from other places and explore other parts of the world, right? So, ya me conocen tal vez como Otis el Pro, el abogado principal aquí en Landerholm Immigration. También soy hombre de familias. También soy biciclista. En el 2005 yo anduve de un lado a otro de este país, de los Estados Unidos, en bicicleta. Y también Otis el viajero. He viajado en 25 países y he vivido en 5 países diferentes. Y pues me encanta realmente ir y conocer otras partes de este mundo. Okay. So that brings me to my why. I often, why am I an immigration lawyer? It's because I believe in the freedom of movement. Yo creo en la libertad de movimiento. And I always ask, why is it that I could travel to each of these countries, live in the countries that are bold and underlined, never once worrying about getting deported, never once worrying about, are they going to approve me for a visa, never once getting caught crossing the border or anything like that. Meanwhile, this image, which shows the wall that, yes, does exist between the United States and Mexico, and the crosses that are on this image represent human beings who have died trying to enter the United States. And it's like, why is it so simple for some people to travel wherever we want to in this world, and why is it so difficult for so many other people to do the exact same thing? That's why, right? So, siempre quiero hacer la pregunta, ¿por qué pude yo viajar a estos países y vivir en los países subrayados sin preocuparme de una visa o de un green card o de nunca fui deportado, nunca fui agarrado por inmigración? Y mientras tanto, aquí está el muro que sí existe entre los Estados Unidos y México, y los cruces ahí simbolizan personas que han muerto cruzando a los Estados Unidos. Y es que, ¿por qué es tan fácil para algunas personas como yo viajar donde queremos en este mundo, y por qué es tan difícil para la gran mayoría de personas hacer exactamente la misma cosa? Y en mi opinión es causado por una injusticia que tenemos en la ley. All right? So, and really the difference, right, between folks that are allowed to travel and folks that aren't is just created by a legal system that creates that difference, and fundamentally it's not fair. It's an unfairness that prefers people with certain types of documents and excludes people with certain other types of documents. So we go to law school and we figure this out, and we start a law firm, and we fight to change that difference, and that's really what we're here doing. So aquí estamos con mi bufete de abogados y estamos aquí luchando casos de deportación y estamos aquí luchando para reducir la injusticia que sí existe en nuestro sistema legal. All right, so that's it. So that's all I'm going to say about me. We're going to talk now about our main topic for this month. So es todo lo que voy a decir acerca de mí y mi oficina. Ahora vamos a enfocarnos en el tema específico del seminario del mes de este mes. Okay? Y este tema es ¿qué opciones hay en Corte de inmigración? So the theme for this month is what options do I have if I'm in immigration court? All right. So there's four questions that we're going to answer just to make sure that we're all on the same page. The first is what is the notice to appear? All right, and this is an important question. The second is, how can I know if I am deportable, right? The third is, how are the hearings like in court? And the fourth are, what real options do I have to present in front of the judge? Okay? So, en español hay 4 preguntas que vamos a revisar juntos ahora. La primera es, ¿qué es la noticia de aparecer? Okay? La segunda es cómo puedo saber si soy realmente deportable bajo las leyes, ¿ok? La tercera, cómo son las audiencias en corte, ¿ok? Y la cuarta, qué opciones tengo, cómo puedo ganar mi caso, ¿ok? Qué opciones hay, qué aplicaciones puedo someter ante el juez. All right, so that's that. So the first question, what is the notice to appear? All right, in immigration court, if the government thinks that someone is here in the United States without lawful permission, or if they think they've somehow violated the terms of their permit, their visa, green card, whatever it is, here in the U.S., the government has to file what they call a notice to appear to the immigration court, and they have to give you a copy, all right? So if you are in immigration court, you definitely have one of these documents somewhere, right? Even if you've lost it, it's on file in your case, all right? It's a very, very important document. Study it, all right? And the truth is that it's divided. The middle section here, which is sort of the first section that we look at, has allegations, factual allegations that the government is saying are true for you, all right? And this section right underneath it are the legal charges, right? So the government actually files charges in immigration court saying, based on these facts, if we can prove these facts, then we think you are deportable under this section of the immigration law, under this section of the immigration law, and whatever. They charges are the legal sections, all right? I'm going to drink a sip of water. So, to say that in Spanish, la noticia de aparecer es un documento sumamente importante para un caso de inmigración. Si el gobierno piensa que uno está en el país sin permiso legal o que ha violado los términos de su visa o de su green card, él va a someter una noticia de aparecer con el tribunal y le van a entregar a usted una copia, ¿ok? Así que ese documento es súper importante. Aquí arriba hay alegaciones, que son hechos que ellos dicen que aplican para usted en su contra. Y aquí abajo hay los cargos, que ellos dicen que según es tal y tal sección de la ley, usted es, entre comillas, deportable legalmente. ¿Ok? Eso es la noticia, la primera noticia que someten al juez para comenzar las audiencias en su contra. So the last piece that I was saying is that it is this document that the government files, and that's what now the court knows to start scheduling hearings, right? And so now the court administrator will say, okay, we have a new notice to appear, let's put it on the calendar on such and such a judge. That's when the judge gets assigned and all of that stuff through the process of the notice to appear. Okay, great. So if you have a notice to appear, look at it, pull it out, study it, right? Si usted tiene una noticia de aparecer, por favor, sácalo, estúdialo, porque es sumamente importante en su caso. All right. Also, if you've received a notice to appear, please meet with an immigration lawyer because it's time to meet with an immigration lawyer. Si tiene uno de ellos, por favor, hable con un abogado de inmigración. Okay. All right, so now that that's begun, now that we have this notice, right, now we want to know whether or not I really am deportable, right? Should I even be here? Should I have received this notice or not? Sometimes we see that the government files these things and they're actually inaccurate, and the allegations that are on that are not true, right? And so we've got to make sure that we study that, and we want to make sure that we study your specific situation to know whether or not you actually are deportable, all right? So, ¿cómo puedo saber si soy realmente deportable? A veces el gobierno somete esa noticia de aparecer contra personas que legalmente no son deportables. Así que si eso ha pasado, pues tenemos que estudiar bien el caso y explicarlo al juez, porque pues puede ganar su caso si no es deportable, okay? So, we've got to study the charges. Normally, we request FOIAs. FOIAs are like it's requesting your whole immigration file so that we can study them and we can know what the government's arguments really are against whoever it is that we're trying to protect, all right? And if someone is not deportable, then we can file something called a motion to terminate, all right? If the government just got it wrong, and here's your visa, here's your green card, your invalid status, you've not violated the terms of your visa in any way, then we can file what's called a motion to terminate, and that ends your case completely, all right? So para explicar eso, normalmente solicitamos todos sus records de inmigración y se llama un FOIA, okay? Que es el record, el expediente completo de inmigración, y lo estudiamos para estar seguro de si realmente está deportable bajo las leyes, okay? Y si uno no es realmente deportable, si todavía tiene su visa, si todavía tiene su green card, nunca ha tenido ningún problema y realmente hay un error ahí en el sistema, la opción es que hay que someter lo que es una moción de terminar y pedimos al juez que termine de una vez todos los procesos en su contra, ¿ok? Y hemos ganado mociones de terminar y lo sometemos de vez en cuando aplica, okay? So, awesome. So I was just explaining that we have submitted and we have won motions to terminate, and they are a thing, and if somebody isn't actually deportable, then that's what we do, okay? Cool. Okay, so at this point, I wanted to take a brief pause, and I wanted to hold up the fact for everybody on Facebook. So this is a book that I wrote that basically is talking about everything that we're mentioning right now. And for those of you who are here, I'm sure you already have a copy of it, but I'll give you a free copy just for being here, so thank you for that. And there's Fernando, just in case more folks show up. And here's the deal. If you're watching this on a Facebook Live right now, all right, if you send the text ICE to this number, 510-646-0904, we will give you a free copy of my book, all right? And that will be a resource for you if you're facing this process. And I'm going to explain that in Spanish too. Mira, di una copia de mi libro, el libro que escribí yo habla de esos temas, ¿ok? Y es un recurso, y si usted está viendo eso, por favor mande un texto. El texto puede decir ICE y que lo mande a ese número de teléfono 510-646-0904. Y si lo hace ahora, le vamos a mandar gratis una copia de mi libro. ¿Ok? Así que gracias. Cool. Enough of the commercial. So, good. So, ¿cómo son las audiencias? So, how are the hearings? All right? Basically, there's two types of hearings. There's master calendar hearings, and there's what we call individual hearings. In a master calendar hearing, we'll be sitting in the courtroom, and there's lots and lots and lots of different people, and everybody's got their lawyer, and it's very, every judge looks at every case, and it's, 5 to 10 minutes. Each case has their turn in front of the judge, all right? We're not arguing anything substantive. Basically, the purpose of this first type of hearing, a master calendar hearing, is to plead to the notice to appear, which we just looked at, and to tell the judge what's our strategy, right? And to file documents sometimes, but basically to explain to the judge what our strategy is, all right? At that time, depending on the case, but sometimes a judge will set the final case for a trial, all right, for what they call the individual hearing. The individual hearing is the immigration word for a trial, all right? And basically, if we're going to submit, say, an application for asylum or an application for cancellation of removal or an application for some other type of green card, right? Then, and if we're fighting about it in front of the judge, then the judge will set it for an individual hearing where they will hear all of the history of the individual. They will go on the witness stand. They will explain their case and show evidence of why they, should win whatever their argument is. Okay? So I'll explain all that in Spanish. So, en Corte de Inmigración hay dos tipos de audiencias. La primera es una audiencia master, okay, que realmente es una audiencia preliminar. Cuando uno va a su corte preliminar, hay muchísima gente allí. Cada persona va a tener su abogado. A veces hay personas también que no tienen abogados. Pero cada persona va a tener unos 5 a 10 minutos normalmente ante el juez. Básicamente para explicar cuáles son cómo va a ceder o negar los cargos en su contra y también qué aplicación va a someter, ¿ok? Qué estrategia va a hacer para luchar su caso, ¿ok? Eso es como el primer tipo de audiencia. La segunda audiencia se llama la audiencia individual, que es como el jurado final. Y es un jurado y en la audiencia individual el juez va a escuchar los detalles de usted, de su vida, para realmente poder tomar una decisión buena de si usted califica o no para la aplicación que va a someter. Okay? So that's that. So then, now that we know the process, now it's like, okay, so what arguments can I even make in front of the judge, right? What options do I really have? And so that's what really we'll go through right now, and there's 8 of them that I'm going to discuss right now, and we'll go through them one at a time, all right? The first is to argue that I'm not deportable, all right? So I'm going to explain what I just said real quick in Spanish, and then we'll do each of these English and Spanish, and then we'll be all done. All right. So ahora voy a explicar realmente, ahora que sabemos el proceso, vamos a enfocarnos más en realmente qué opciones hay para someter un caso ante el juez, ¿ok? Y la primera que ya revisamos es argumentar que realmente no soy deportable. Así que eso es una opción. Y si podemos ganar eso, pues ya puede terminar el juez el caso. Okay? So if we can win this, arguing that we're not actually deportable, then that's it. That's the end of our case, and the judge can terminate proceedings. All right? The second option is what we call a motion to suppress. All right? If the government makes an arrest of someone, if the government uses evidence that it shouldn't, like the government's allowed to arrest certain people, but if the government arrests someone in violation of their rights, right? If immigration uses evidence obtained after violating people's rights, we can file what's called a motion to suppress, and it's very, very difficult to win these in immigration court. But we've done it, we've won it. It is possible in certain instances, all right? So I wanted to highlight it. So la segunda se llama la moción de suprimir. La cosa allí es si inmigración le arrestó a usted en violación de sus derechos legales, o si inmigración está intentando someter evidencias en su contra y las evidencias que tiene los obtuvo bajo violaciones de la ley, a través de sus propias violaciones de la Constitución o de la ley, pues hay una moción que existe que puede suprimir las evidencias en su contra y es otra opción para poder ganar su caso. All right? No es súper común, lo hemos tenido, lo hemos ganado, pero no es súper común. Okay? Pero sí existe y es una opción. All right. The third option is, and we'll talk about this for a few minutes, is an application for asylum, all right? Asylum means protection, okay? And the idea about asylum is that you're afraid for your life to go back to your country because wherever you're from is not safe for you, all right? And specifically, you've got to show that you have a well-founded fear of persecution, and it's got to be on account of one of 5 things. It's got to be on account of your race, your religion, your nationality, your political opinion, or your membership in a particular social group, okay? But, yeah, so it's not easy to win an asylum case, but if you can show those things, right, then we can put forth an application in our office, or an application for asylum about that thick, right? It's a big book that we end up basically putting together to show why you legally, meet the requirements and why your life really would be at risk for one of the specified reasons if you were to go back to your country. If this is your situation, and if you really are afraid for your life to go back to wherever you're coming from, please speak with a lawyer. Really, if you're facing immigration court at all, please speak with a lawyer. But asylum is especially risky and an especially complex area of immigration law. All right. So, para explicar eso en español, to explain that in Spanish, la tercera opción es una aplicación de asilo. Y asilo significa protección. Y la idea es para proteger a personas que están huyendo por sus propias vidas y que realmente sus vidas estarían en peligro si vuelven a su propio país. Y hay que comprobar que tiene un miedo razonable de persecución por uno de 5 motivos. Tiene que ser por su raza, su religión, su nacionalidad, su opinión política o, entre comillas, su pertenencia a un grupo particular social en su país. Así que hay muchos requisitos legales, pero mira, si usted realmente tiene miedo por su vida de volver a su país, por favor que tenga un abogado que va a realmente luchar por usted, porque casos de asilo son riesgosos, no son fáciles, es un área de esa ley bastante complicado. Así que llame a mi oficina o llame a un abogado bueno y arme bien su caso. En mi oficina una aplicación de asilo es así de grande, es básicamente un libro completo demostrando las evidencias de por qué usted califica legalmente para asilo. Okay. So we talked about contested removal hearings, which are arguing that you're not deportable, motions to suppress, and asylum applications. The fourth is what we call cancellation of removal, all right? Cancellation of removal is a term that, how can I say it? It's sort of, if someone is undocumented, right, and if they've been living in the United States for more than 10 years, and if they can show that they have a United States citizen or permanent resident, spouse, parent, or child who would suffer an amount of harm that is like incredibly high. They call it exceptional and extremely unusual hardship. Like if somebody's like suffering from medical illnesses, or if somebody's autistic in your family, or if somebody's got Down syndrome, or if somebody really would depend on you for their basic survival to meet their basic needs, then the law is written in a way where the judge can cancel your deportation even though you are in removal proceedings, right? And so yeah, there are actually 4 different types of cancellation of removal. I'm not going to go through all of them right now. The main one is the one I just emphasized. If you've been in the United States for 10 years and you have a family member who is a U.S. citizen and who would suffer a very, very crazy high amount of harm if you were deported, then yeah, you can apply for cancellation of removal. And our office has done that. Our office has won that, and it's it's a very sensitive application, but it is one of the big options available. If you already have a green card, I should explain this too. There's a type of cancellation of removal out there for people who already have green cards, all right? And you might say, well, why would I be in removal proceedings if I already have a green card? The answer is because of crimes, right, typically, or fraud, right? But typically the government would allege that, some criminal record now was a violation of the green card status, so they're going to take away that green card and put you into removal proceedings. Well, if that's you, there's also a type of cancellation of removal that can help you in that situation, depending on what the criminal charges may have been, or depending on some other factors. And so if you have a green card but are in removal proceedings, think about this as a potential strategy for you. Okay, great. So now we'll talk about the 5th, which is what we call an adjustment of status. all right? So an adjustment of status is actually, it's typically not done directly in front of the judge. It's typically done in front of United States Citizenship and Immigration Service. But the common scenario is, look, say you were in immigration court proceedings, but now you've married a U.S. citizen, right? Or say you've now been eligible for some other petition that was filed on your behalf, right? If that happens, then okay, yes, you were deportable, right? And you're going through the process right now, but you're eligible to adjust that status, to actually change your status from being either undocumented in the past or having a visa overstay or whatever the situation was, and you're eligible to change that so now you can apply for a green card, all right? And so what we do in this situation is it's a fairly common way to stop removal proceedings, right? So if there's a marriage, we have to show that it's a legitimate marriage. It's not just for immigration purposes, but you actually love each other, right? And if we can show that, then we file the application for adjustment of status. And then after we go through that process, as that process continues, we file what we call the motion to terminate in court. So that way you don't have to continue with the hearings in front of the judge, and you can just continue in front of the Immigration Service with your application for the green card. That's commonly the strategy. Another approach is actually to submit your application for your green card based on marriage to the actual judge, all right? But my preference, whenever possible, is to first submit it to the Immigration Service because they can adjudicate it, and then you can be done with it. And it's a lot less stressful, a lot less costly, a lot less of a nuisance, really, to prepare everything and then to have to be on the witness stand in front of a judge. Okay, great. So I'll say that in Spanish. So la aplicación número 5, que es bastante común también, se llama el ajuste de estado, ¿ok? Y la cosa ahí es que si usted está en el proceso, pero si se case, por ejemplo, con un ciudadano estadounidense, pues podemos someter una moción para su green card y realmente es pedirles que ajusten su estado legal desde indocumentado, que antes estaba, desde un visa overstay, como decimos, hasta un residente legal permanente, ¿ok? Y normalmente la manera de que lo hacemos es que sometemos toda la solicitud. Por ejemplo, si usted se case con un ciudadano, primero hay que demostrar que la relación es buena, no es solo por inmigración, pero realmente se quieren, ¿ok? Y después de eso, pues podemos someter la solicitud con todas las pruebas de su ajuste de estado, ¿ok? Okay, perfect. So then number 6 is what we call waivers, all right? There are certain waivers out there that we can submit in immigration court, all right? Where this often comes up is with immigration fraud. So if you were put into immigration proceedings because you lied at some point on an immigration application, which is very, very common, you know, it is. It's very common. We see it commonly, at least. So say, for example, you know, you really wanted to get into the U.S. and you said that you were, you know, coming in as a tourist, when in fact you wanted to, you know, you had a job that was already set up and therefore you weren't a tourist, right? And so when you applied for that tourist visa, you actually misrepresented yourself and now you've committed a fraud. Well, if immigration were to catch wind of that, they could put you directly into immigration court, even if you still had your visa, you know, in your passport, even if you still had time left on your visa. They could put you into immigration court for fraud purposes. There are waivers that exist that can help take care of fraud. The main one is a 237A1H waiver. There are a couple of others. There's a 212H waiver, which can waive crimes and things like that. I'm not going to go too far into waivers right now. Just know that if you have certain special kind of situations, you know, basically we've got to request your full record and we've got to see really what the problems are in your record and then see what strategy, which of these options will work the best to win your case. Okay? So great. So we talked about waivers. Let me say that in Spanish because I don't think I did that yet. So también hay perdones. El sexto, la opción sexta es un perdón. Y eso es diferente que el perdón que escuchamos, que es del castigo de 10 años cuando uno sale del país. Eso es un perdón que hacemos ante el juez de inmigración. Y la que vemos con más frecuencia es un perdón por fraude. Así que si usted mintió al momento que aplicó para su green card o algo así, pues hay una manera de pedir un perdón por eso y lo hacemos y lo sometemos ante un juez. Okay? Perfecto. All right, the seventh option that I want to discuss is what we call the U visa. All right, and I'm going to take a drink of water real quick here too. I like to talk fast. Keep things moving. All right, so the seventh option is what we call a U visa. A U visa is a special visa, and the idea is it's for people who have been the victims of crimes here in the United States. So if you know somebody who's been the victim of domestic violence, or has been the victim of an assault, or has been beaten up on the streets, or has been the victim of some kind of extortion, or some kind of something bad here in the U.S., and if they've reported it to the police. So you have to have called law enforcement, you have to have given a police report, you have to have been cooperative in the investigation or the prosecution of the crime against the bad guys that did that to you, right? And if you've done those things, then you may qualify for what we call a U visa. And U visas are wonderful because you can apply for them. Typically a visa, you have to leave the country and then apply from out there in order to come back in. Well, a U visa, you don't have to do that. You can apply here in the U.S., you don't have to leave. And it's a way, if somebody's in immigration court and applying for a U visa, what we do is we send the application to the Vermont Service Center, and then it's to USCIS, the Citizenship and Immigration Service, and then we file a motion to administratively close your hearings so that we actually don't have to go back to court while your U visa is pending, because U visas take a long time, all right? But that is a good strategy if you're in that situation to prevent a deportation. So great. So in Spanish, también una opción es la visa U. Y la visa U es para personas que han sido víctimas de un crimen aquí en Estados Unidos. Así que si usted conoce tal vez una persona que fue víctima de violencia doméstica, o de un asalto, o de una extorsión, o de un problema bastante fuerte aquí en Estados Unidos y que lo haya reportado con la policía, hecho un reporte a la policía, pues si usted ha hecho esas cosas, puede tal vez calificar para una visa U. Y la visa U es súper buena porque uno puede someterla estando aquí en Estados Unidos. No es como los demás visas que hay que salir primero para aplicar en su consulado en su país. Pero la visa U lo puede hacer aun si está actualmente enfrentando deportación. Y lo que hacemos si está en Corte de Inmigración es que preparamos y mandamos la aplicación de la visa U al Centro de Ciudadanía e Inmigración aquí en Estados Unidos, y mientras sometemos una moción al juez que administrativamente cerramos el caso ante el juez para que no tenga que siempre presentarse con audiencias ante el juez de inmigración. Puede cerrar los casos en corte, esperar los resultados de la visa U, ¿ok? Así que si usted fue víctima de un crimen o de un abuso bastante fuerte aquí en Estados Unidos, pues es una buena opción si está en corte de inmigración. Okay, perfect. And then the last one is the one that I like the least, and it is voluntary departure. And so I have to mention it because it is one of the applications that you can request in front of an immigration judge, but it's not really my goal ever, right? This can always be plan C, plan D, plan E. After we've tried all of the other strategies, we can request, rather than leaving with a deportation order, we can request to leave under an order of voluntary departure. And typically we have to spend a bond. We have to pay $500 to the court. That basically guarantees that we're going to buy our own ticket, and then they'll pay us that money back once we have actually removed ourselves from the United States. And so sometimes, if we don't have very many options, sometimes we'll do, asylum, but with application for voluntary departure in the alternative. Or we'll do cancellation of removal and asylum with an application for voluntary departure in the alternative. And so, that exists also. So I'll explain this in Spanish. La última, que realmente es mi menos favorita, se llama, y realmente es pedir al juez y someter una aplicación al juez que el juez le deje no salir deportado con una orden de deportación en su contra, pero salir voluntariamente. Y hay que pagar una pequeña fianza, es $500 normalmente, para poder comprar su propio boleto de avión, salir del país, y después de que ya está fuera del país le regresan los 500. Normalmente la salida voluntaria lo solicitamos como un plan C, un plan D, un plan E, si nuestras otras estrategias no fueron exitosas, ¿ok? Así que, pero a veces también es una buena estrategia si la mejor opción es a través del consulado americano en otro país. Así que eso es algo que no voy a explicar mucho ahorita, pero sí, a veces la salida voluntaria puede ser la mejor estrategia, pero normalmente a mí prefiero buscar una estrategia que puede dejar a uno permanentemente quedarse aquí en Estados Unidos. Awesome. So that is it. So that is basically the big main categories of options that exist to fight for someone who's facing removal proceedings. And so really, what I'd like to leave everyone with is, how can we help, right? So obviously first, we have consultations, right? And if you're facing removal proceedings, please have a consultation with my office, with a lawyer who's good and who does these types of cases, all right? Also, request all of your immigration record. We want to be able to study exactly what evidence the government might have in your file, right? And we want to know that so that we can be prepared and we can prepare you as best as we can for it, all right? Which brings me to my third thing, is actually prepare as best as possible. Prepare the best application that you possibly can before submitting anything to the judge. And really, our office, we do a great job of helping people strategize, Just because you might not qualify for anything today doesn't mean, hey, we might try, put one application on file. We'll put one application on file right now. It'll be in process for the next 3 years, and then 3 years in the future, your visa petition that your brother submitted 10 years ago will be ready to use, and so then at that time we'll be able to take advantage of it. So there's lots of strategy that goes into, hey, we'll try this now, we'll wait and see if the law changes, and then if it doesn't, we'll try this, and that's really what a good lawyer can help you with, so that you can navigate the system and use the laws and the regulations to your best possible advantage. All right, cool. So in Spanish, I'll say this and then we'll wrap up. So, ¿cómo podemos ayudarle? Mira, primero, si usted está enfrentando deportación o está en procesos de deportación ante el Tribunal de Inmigración, por favor que haga una consulta con un abogado bueno, que realmente ha ganado casos y que realmente entienda cómo manejar casos complicados en Corte de Inmigración, ¿ok? La segunda cosa es que hay que pedir todo su expediente, hay que saber por lo menos qué evidencias tiene el gobierno en su contra dentro de su archivo, ¿ok? Así que nos puede ayudar en muchas maneras, preparar bien para su audiencia final y preparar bien la aplicación que va a someter. La tercera es realmente preparar lo mejor posible cualquier aplicación que va a someter al juez, porque la aplicación que somete, pues es todo, ahí está todos los chances de poder ganar su caso y de poder permanecer aquí en Estados Unidos. Y el último, pues en mi oficina podemos pensar en las estrategias para maximar, para darle los mejores chances posibles de poder ganar su caso y quedarse aquí en Estados Unidos. Muchas veces o con mucha frecuencia no hay una opción hoy, pero lo que hacemos a veces es, si intentamos esta aplicación hoy, luego en 3 años a veces hay un hijo que va a cumplir 21 años, o hay una petición que fue sometido hace años atrás por un hermano o algo así, y que en unos 3-4 años va a estar válido. Así que podemos someter tal y tal aplicación hoy, ¿ok? Sabiendo que no es la estrategia mejor a largo plazo, pero es como el método, pues, para poder preservar la petición o el derecho de usar una petición en el futuro, ¿ok? Y es sumamente importante, eso es lo bueno de tener un abogado que realmente entienda esas cosas, que podemos manejar el sistema y pensar en realmente cuál va a ser la mejor estrategia para ayudarle a usted ganar su propio caso, ¿ok? Así que that's really it. Let me see. I think that's it. So thank you very, very much for coming. Y gracias por venir y por estar conmigo en internet. And thank you very, very much. So that's it. Yay!